case briefs, and so much more. LSData's got what you're looking for.
In 1990, the Supreme Court of Texas heard a case, Bockelmann v. Marynick, which revolved around the liability of a tenant who had vacated a jointly leased property before the lease ended. Brenda and Hermann Bockelmann had signed a one-year lease together, but Brenda moved out early, while Hermann remained and continued paying rent. When Hermann eventually defaulted on rent and loan payments, landlords Samuel and Sharon Marynick sued both tenants for unpaid rent, repair expenses, and the balance due under the loan contract. The Court of Appeals initially held Brenda liable for Hermann's holdover tenancy, claiming her joint obligations under the lease continued due to Hermann's continued occupancy. However, the Supreme Court reversed this decision, stating that one tenant is not jointly liable for the holding over of another. The Supreme Court determined that the original lease had a definite term and simply expired at the end of the contract period, so Brenda was not responsible for Hermann's actions after she left. Hermann's holdover tenancy was considered a new tenancy for which he alone was liable, and Brenda should not have been bound to the new arrangement. Consequently, the Marynicks were not awarded anything in the case.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.